Sami Jemfi. Akwa bana pom te saying. Bibi Ekoi.
Unyamedia che ye tiasi na katrema edayimu na mojadi mu ofusani de ye de aseda be menyame.
Obi the message by say na all show TV so no. Na say udimi na you too calm. Aden.
Well, I don't know. The nipakon who yentia wakasa, but for me, I was just being myself. So that is how I speak. So nipana who's na my calm the idea that is how the person sees it. I cannot begrudge the person, but for me, there was no difference. That is how Sami Jemfi speaks. Yeah.
Okay. And you're different from the Sami Jemfi we know.
No. Oh, well, last week I was there. I think on Thursday I was the one who briefed the media.
Yeah.
And maybe the
Lawyer Mesa said within this election petition period, no, we're redefine some. As a
4-5 days.
Or say we're redefine. That's we're redefining about it.
Oh, redefining no, redefining the Sami Jemfi that way. No, it's good. It's good. Because okay, last week
or response to him,
I say, Arobashi Shadow cry yenjay, and I agreed with him.
Okay,
and that's the response was good.
No, I'm coming.
Yeah, me too.
You play dual role. What you have here? We are politicians, and at the same time, we are lawyers. So, as a politician, the way I will speak on a public platform definitely will not be the way I will speak as a lawyer at the premises or on the premises of the Supreme Court of Ghana, depending on the issue. So, you are explaining a matter, court, etc. It cannot be the same as commenting on a political matter on radio or on a political platform. And on Tuesday, it is a different agency. No. It just means that issue be a and even in communication, even with regards to political communication, audience be our address, they determine how you speak. So it's not any big deal. Only I mischief,
Usumana from last week Thursday, it was a Wednesday.
Yeah,
it manifested your speaking.
Yeah.
Nandadi so ma mo hwe wo TV do menwa J papa that this my Sami Jemfi that I would love to be working with on the regular. Echi mo comment do as they know. Oh, Sami
and then so yet another I don't know, for the want of a better word, no setback as far as the petitioner's quest for justice in court as far as this petition is concerned, no. Big blow 9-0 ruling bill from the apex court of the land on more application for review. Court said even for the minimum threshold in bringing a review application, no, you couldn't meet it based on the argument I'm putting forth.
The problem is that you've been listening to Kojo Oponkroma, who has been using wrong legal language. There is nothing called minimum threshold when it comes to application for review. So if he's speaking as a lawyer, you use the right, terminologies and you're gonna say statements. There's nothing like minimum threshold. What is minimum threshold? The court says the petitioner did not meet the minimum threshold. The court never used any such phrase. What is called minimum threshold? Maybe he's talking about the conditions that an applicant or person court to review the decision. It wasn't meeting, or we did not meet those conditions. Like they should not use words like minimum threshold. I think lawyer Japamesa is senior to Kojo Ponkoma. Also correct you. That is minimum threshold. Mepacho, in our opinion, we met the preconditions that must exist before a person can invoke the review jurisdiction of the Supreme Court. Waya dream no. Enyema na wo se yetimi eshow na timi ama court na sesa na adwen and now was the decision I will take here on 16th February on the someone I go to the name need the moment you find a real P case, their decision on that application for leave, we believe say the ne was a the ne was a there was a trade be a and fulfill all the preconditions are necessary for the court to review his decision. Because Obi, what because that condition a different condition. The condition, let's say, there should be exceptional circumstances. Okay?
Yes.
Such as
Ekosiisen on Asempa
cases
FM.
where the court has committed fundamental errors of law. Which errors of law have occasioned a miscarriage of justice? So, mechanic somewhere. I just say review and just appeal. Untimin because the court has taken decision. Many court now review. No. Appeal near by review and review dear. The first I want to court on the yard interest will be me a court and so review the decision. But I was out saying
Asempa FM.
be serious, be a there's a court now you from so one a certain basic or fundamental error of law. And I say at the BIA there wasn't a court not taken into consideration. Court not taken into consideration in arriving at that decision. They don't have exceptional circumstances. So you are bringing it to the attention of the court and to appeal to the court on the basis of this. Mudi can wait there and so need him. And I said, where the two Supreme Court said, and I'm surprised that counsel for the respondents, and in fact, to some extent, the bench would say that we were re-arguing the case as though it was an appeal. I don't get it, in my humble opinion, because the grounds of the review application and the lawyer are clear. We are talking about Emra, Ghana Mra, I was a court to the year Juma. In the court decision of 16 February, Oman find the Juma, a big Oman Mosokra, which renders the decision per incurium. Per incurium means that the manana contain and at the Fufra and Mraditia. And he gave so many examples. Number one, Section 72. Section 72 of the Evidence Act, clear, says assembly cost of court. Say obi wo ho na say ni pakro the interest and the interest of a party in that case a party, an adverse party in that case, limit to me as samai sa ni pakro no se bra na be dia dance na me toto ano say be ya asem no mu no kura beba because wo say ni pakro no only me opponent in this case mo interest and no be na me de GRA example chair last week say be only GRA for 3 months so now in that case the interest of the Commissioner General of GRA is substantially the same as the interest of GRA. You as a party, you can call that commissioner to come and give evidence and examine him as though you are cross-examining him. And in this case, Jimensa is a person. The interest in this election petition case is substantially the same as the interest of the first respondent, the EC. Because I don't get EC in the ban of the and your no put declaration here challenging. She is not a party, but as a person, her interest is substantially the same as that of the first respondent. Section 72 says you can call her to come and testify. But court, decided the application for leave to reopen our case and to subpoena Jimensa. In what capacity are you going to subpoena Jimensa if leave were to be granted?
I think Justice Tokono and Ebusa.
Yeah. As an adverse witness. And when you have adverse witness, in the laws of Ghana, you are talking about Section 72 of the Evidence Act, 1975. That's what you're talking about. Yet, courts, Evidence Act, I know what some of the year Juma as
Ekosiisen on Asempa FM.
There was no reference to that statute and that provision. Rather, they made reference to the Black's Law Dictionary, which is applicable in common law jurisdictions, including Ghana, but which has no binding effect on our court. As I said, courts no power and our best. It is only of persuasive effect. And yen shema court to say, obe follow Black's Law Dictionary. The yen shema court no say court no de be juma in deciding cases. Our laws, including acts passed by Parliament. In this case, the Evidence Act, Section 72. And not the court on our motto, Black's Law Dictionary in a court on the boss. And then a court on the kind. Court and say, Black's Law Dictionary definition of an adverse witness. I just say, Ubia, your friend Amana Betana Dekamuse would or my Odia dance here. Now, Okusutia dance here, no, the evidence in chief no mono. Ye who say na asem a wo ka no ene nipa kora wo frɛ no na wo toto na no na asem no boagura. So the person is giving evidence which is adverse to the interest of the party examining him. Then that party can then apply to the court to say because we are down in case boagura the moon treat as a hostile witness or an adverse witness. That is what the court said based on the Black's Law Dictionary. And we told the court today say respectfully need you because Section 72 there was somebody here, you didn't even refer to it. And if you had referred to it and can who say and no credit that say I was say obi betina dakamu emma evidence and some yetimiaka so adverse witness. That is one option. Nipa no betina dakanim because obi ubetimi lawyer message said now ma court. Now what friend Dominic is here, so media dance him up. Would you say Dominic media dance him out? Or by another 10 years out? In that case, the court can be as envisaged by the Black's Law Dictionary. You can apply to the court and treat this witness as an adverse witness, even though I called him. Because na dance na all man, and then master more about that is one option. But Section 72 talks about something different, which is that Nipa Chrono or Wabakoto, Makoto, why Affidavit, why depositions or Nebio, once or Tinibe Bimpo, none the interest, any the interest of a party in the case, you can call the person to come and give evidence as an adverse witness. That is the Ghanaian law, Section 72. The court didn't make reference to that in their ruling of 16th February. And even today, if you look at their decision, clearly we disagree with it. Because what are they saying? What they said was that, respectfully, there is no contradiction between Section 72 and the Black Law. Clearly, there is a contradiction because whereas the court is saying that the Black Law Dictionary says, I just say, Obia Radakamu, Abedia dance here, and Sunny Yetinyaka saw an adverse witness in situations where the testimony be adverse to that of the party who called and examining the person. Section 72 says the person need not be in the box. Obi, down, just Google Evidence Act 1965. Read Section 72. I mean, we can all interpret that language there. A person, in fact, it even says a party, which defeats this whole argument that a party cannot be compelled to give evidence. Section 72 says even a party can be compelled. Or if you are not compelling the party, a person whose interest is substantially the same as that party as an adverse witness. As an adverse witness. So Lawyer Chachuchikata was right, and we believe that he is still right. The justices of the Supreme Court now, Omona, Omu interpreting Brano, they've interpreted it differently. Say Omoni and Nyagri, actually. We disagree with them, but what they have said is what prevails. That is what is the law. But like I said today, the fact is that Obiako courts, not court abon asem wetu and say courts on your right. If I call you wrong.
But Mami Musa Sasemi and what was so on Section 72 na sisi our site, unse the end was a review application on the ruling of 16th. And before ruling of 16th, Lawyer Chachuchikata argument. And so now we see the argument on 16th now, or center a bit more on Section 26
Yeah, I'll come to 26.
Meba. Section 26 no on the thing about presumptions. Easy ni make some Estoppel or make some representations be, and amongst you had no doubt you believe those representations to be true. In the Namufi said Obeba Babi Jina box nim. He centered a bit more on that. And then no, as a focus now for shift yako section 72 in this okay.
Because and then or argue on 72 as one ground. That was ground A. About ground B, he argued on section 26. So don't say
no. The American said 72 no was not 72 no was not advanced in
what I'm coming to.
Before.
When he was asked, in what capacity are you going to call Jim? Okay. I'm going to call her as an adverse witness. And in Ghana, what kind of adverse witness? Because it takes the Evidence Act. That is the title. In fact, that is the heading, rather. That is the heading of section 72. It is on the left. Adverse witnesses. So when you're Ghana, when you're as an adverse witness, are you again talking about section 72? That's the only provision in our Evidence Act about adverse witness. And see, and no, it's neither here. Let's even talk about section. And on section 72, the point is, if there is no contradiction between the Black Law Dictionary and section 72, why did you quote Black law and not your own law?
But what stops them from quoting Black's law?
Okay.
And then Estoppel from quoting Black's law.
Nothing. It is absolutely right for them to quote that, but you quote that in addition, and only a secondary. Normally, the court, my little knowledge in the law, will quote the statute first because that is the law of the nation, that jurisdiction, which is binding on the court. Now, other authorities are, and also what persuasive effect, and then also what a certain bearing on that, they quote it. But you don't leave out the law of your country and then quote a common law rule or principle or Black Laws Dictionary applicable in common law, which is, by the way, has no force of law. It has no binding effect. Let me use that on the court. Let me use that rather. So, clearly, still, then secondly.
So I mean, answer now, secondly, I think for clarity's sake, very important. So we share the court's decision not to quote section 72, so the wakano a statute in the hierarchy of Mrano statute neba before even CI and LIs, not to talk of dictionary be definition. But I share rule 54 of CI 16 Supreme Court rules now. With your leave, part 5, about review, or say, the court may review any decision made or given by it on the following grounds. 2 grounds now, 1. Exceptional circumstances which have resulted in miscarriage of justice. B. Discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time when the decision was given to Wayne. The only 2 grounds for review. Sir, the refusal to quote 72 and rather focusing on Black Laws Dictionary, and he found a folly.
Do you understand what you? Oh, hold on. When the first rule you wrote, you read section 54. Exceptional circumstances.
Yes, which have resulted in miscarriage of justice.
Fundamental errors of law. That's what it means.
Fundamental error of law.
I don't need a friend of exceptional circumstances.
Yes, the American say the fundamental error of law should result in miscarriage of justice.
Hold on, the fundamental error of law here is the fact that the court made a decision on who an adverse witness is, without recourse to the Ghanaian law on who an adverse witness is. So clearly, the decision is without regard for the law. This is a statute passed by Parliament on who an adverse witness is. Then you go and give a definition of who an adverse witness is without making any reference to that provision. And that definition you gave is contrary to that provision and law and on the what will apply. So that is a fundamental error of law. In fact, it's not just a fundamental error of law. It makes the decision per incurium. It means that it violates a statute. the court failed to apply that statute, and that is what counsel for the petition. So it no comes under exceptional circumstances now. That's number one. Number two, the issue of miscarriage of justice in the crowd here, that one is a given. Like counsel for the petitioner argued today, and I'm happy that in today's ruling, the court didn't make that suggestion, because last Thursday there was a suggestion that you've spoken about breaches, court apply fundamental error, but you have not demonstrated the miscarriage of justice as occasioned the petitioner. And today, counsel for the petitioner said, look, the court has decided in the case of Tete versus the Republic that once the court has violated a statute or has failed, let me put it that way, to apply a statute, you don't need to prove a miscarriage of justice. That is injustice enough. It is sufficient injustice. In defining who an adverse witness is. One fan Juma, one Mosumpo, definition of what the abandoned is Amrani work. And that is our opinion. That has been our position. So clearly, that is why it was one of our grounds for review, and we still hold the position that is the correct position of the law. Now that Section 26 as someone making Obi, what has been the argument? Ruling now, apply for is review now. Ruling they say we cannot apply Section 26, or Section 26 is inapplicable because of Order 38, Rule 3E5. And they say, wait there, the court no need you, because Section 26 say if a person by her act, statement, or omission, deliberately or intentionally, makes another person believe a thing to be true, and that person relies on that belief or acts on that belief, the truthfulness of that thing will be conclusively presumed again. Just in simple terms, OOP. One man, Sami Jensini NDC, what you say, and then social distancing, I'm a person, Minyano, a Japanese and Kwan, never representing MPP. NDC be connected via Zoom, for example. This is just hypothetical. Then NDC for say yate, and ye crano program ni nyamba because of the wakano. Nti ye be ya prepare say ube free Zoom ni akasa. Abe time no so ya, uzi Zoom ne crano ni nyanye bi. Opa bra studio na be kasa. Section 26 say, and you say ye ma obi who kwan ma na yesa. Because as someone or kan ye no, NDC for the omo want to sweat the key decision be. Nti ye ma ne kwan ma ne sesa na no a, ano sesa na adwen a. Intentia ebedi NDC for. Obviously, what you say. So the air can say Section 26 as somewhere can you say. Dimensa Bible say when you want some yedi be bua obe man na yedi be bua for. Ono aka enya say odena no want say ko was on plus 5 see a so na no.
Sempa FM.
The message on my person obisa me.
Ekosiisen on
man ne kwan ama na bisa me kra na. Intentia bi eniwa ebeto no because Sansem ya obetiye bisame your cross examination. Abe cross examination time asona brani emisawa. After such petitioner not close to the case area, knowing that based on their kind you'll be available for cross examination. What's the master margin? If your Section 26 should be applied so that you cannot change your mind. Then the court quotes Order 38, Rule 3E5.
3E5.
It has got nothing to do with that why I can, because number one, that order it talks about a party, the witness, the witness statement obey to choose not to call that witness. Zimenza is not a party, so we are not even discussing parties here. We are talking about a person. So why do you talk about Order 38? Where is the relevance? Number two, Obi, we are not even talking about witness statement. Say Jimensa, if you choose not to call Jimensa as a witness, even though she has filed a witness statement. That's not the issue. Order 38 Rule 3E5 is about witness statement. But the Canada Section 26 is about her depositions in her affidavits. The two are different. Witness statement there, I must say, you find in your metana de camua, in your may evidence. I just want better than the camua try and then I adopted. I know what about the depositions in her affidavit?
Depositions in an affidavit.
And order 38 rule 3E5 doesn't apply.
Same,
Depositions
but depositions in an affidavit.
It only applies to a party in reference to that they are no longer willing to rely on their witness statement.
Okay.
So clearly, the court decision on Section 26, in our opinion, also was a fundamental error of law.
Same, my question is:
can anybody say this was an appeal and that we did not demonstrate exceptional circumstances?
Okay, my Musa question way. Depositions in an affidavit are in opposition to some interlocutory applications from the petitioner. Our court, and I remember in one of their rulings, said those applications have been dealt with. They are not matters in the current trial, the current issue. Our court not consider.
Today the court didn't say that. You see, because some of those things, in our respectful opinion, it doesn't reflect the correct position of the law. Because your case law, I just said it in a statement of case, it is application for reviewer. In fact, the court held a witness bound by honorary representations on the depositions in affidavits at the court below. That was an appeal which went all the way to the Supreme Court. And yet, the Supreme Court went back to affidavits before the court below and said because of this, the Court of Appeal erred in allowing that person to abuse French evidence. Because a contradictory deposition is a one affidavit in the court below. That is the High Court. So this talk about matter statement under oath don't cease to be statement under oath because a matter has been disposed of with. Unyama evidence under oath. Now you can the word the trial. You bet you for Pedri. You for Pedri. I would think I say the matter has been disposed of. So what are you talking about? Is that what people are suggesting? So I don't even want to go there because clearly that is not what the court said today. What the court said today, among other things, with respect to this ground, they say
Ekosiisen on Asempa FA.
There are rules of promissory estoppel. God has it. Say you bet me who do be say or you're bound by assembly where you can. And was saying you may be present. Assembly can the person intent say the other person will rely on it. Did the person actually rely on it in truth? All those are preconditions for promissory estoppel. And that statement must be clear and unambiguous. And in their opinion, these depositions now are ambiguous. They are not clear. Fair. During cross examination. So now the court position is different. Now, this is our position. First of all, estoppel as created by Section 26. It's not even promissory estoppel. And any student of law can interrogate this. It is not promissory estoppel. Promissory estoppel, which has to do with promissory notes and all that, has got nothing to do with assembly. This is estoppel by conduct. So if you quote conditions of promissory estoppel, and apply it in a case estoppel by conduct and in the statement, not necessarily promissory estoppel. We have a problem with that. And Obi. Yamfan say, Mamma on your deposition CDR. Still, Section 72 channel. Section 72 says why your depositions in your affidavit or not. Once your interest is substantially the same as the interest of a party, you or that party can be called and examined as though you are on cross-examination. So, it's clear. What they are also quite on China about your court to the Kayana. What is ambiguous about Jimenez's depositions? In our opinion, we don't see the ambiguity. The woman said, I can just quote her verbatim. I say, no injury will be occasioned or caused the petitioner because he can solicit the answers he is seeking through interrogatories during cross-examination if he so wishes. if or if he so wishes, now we wish to see those answers. What's the mema, Masamano? What is ambiguous about that statement? There is clarity said the woman was intimating to the court that this interrogatory is the one here. Someone young to book may answer.
Ekosiisen on
Petitioner
Asempa
and the lawyer,
FM.
Benya Quenya, Episamis answer during cross examination. So no injustice will be occasioned there. There is no ambiguity, and so we disagree with the court with regards to their decision on that. And again, even if there were no depositions, Obi, Section 72 will still catch Jim Mensah. And that is why, in our opinion, we said that it looks as though Jim Mensah is being shielded. Maybe our people ask us, why must Jim Mensah testify? But why mustn't she testify? Returning officer for the election which is being challenged, her declaration, her utterances, her work, her conduct is what is being challenged. And then counsel for the respondents, the court also can be. Almost we have not even shown why we want to subpoena her, what evidence she is going to give, and how relevant that evidence is. Really, read counsel for the petitioner statement of case. The reason why the Mensah must be made to be testified, all of that is there. Paragraph 28, paragraph 42, everything is there. Yes, ma'am, you know the declaration here, you human being. Or no, that's why I am from so. Or na so ye na de correction aba figures ya sasa ye wu figures ayen fa nya adwuma ene ye we o chene ye we enti onu kwa na betinya me hu asem na wono eye no problem na dance ya obabedi no obedi dance about this thing. Then people say you didn't even show the court the inkling or what the evidence you will be soliciting from her when she can.
The court did not find argument in relation to accountability very convincing. But
some comment on accountability today. All the time I want to be very fair to the courts. So what kind in a different ruling we will have to discuss and analyze that within the context of that ruling. But in this case, they didn't talk about the fact that
they've spoken about that in an earlier ruling. Yeah, so you wanted them to repeat it.
Demonstrate when we brought application for leave to reopen our case and to subpoena Jim Mensah, we didn't show the court the evidence. In other words, I'm just making it simple. The evidence we would be soliciting from Jim Mensah if the court were to grant us leave to subpoena her. Dear na movie bistana dear asem no ba beka na sa asem no emfa so ben ne wo so emma the case a court no di and could you have come by that information through diligence
Ekosiisen on
at the time and how could we have come by that information? That information is only in the bosom of Jim Mensah. Nobody could have divined that information. Returning officer or no one so that condition clearly met it. Then secondly, the condition says you must show the relevance of evidence. Clearly, everybody knows that same way. So, person who could not attend in year. Jim Mensah now on a year about 1 word you mean in our conducted declare your gazette in that say. Now, don't hear critical because we don't even know the figures are original so the declaration. And there has been so many occasions that even the court, the president, my Lord Justice Eniyabwa, has even sought to question the second respondent when they have come across as speaking for Jim Mensah or the first respondent. So she can only speak for herself. So because I am demonstrating this idea and idiom, Obi, I can take the court to and show you.
Lawyer. Sorry?
That the law, the court did not, for her say about court to say, leave to reopen our case so that we can subpoena Jim Mensah. Obianim say about the rules of subpoena, issuing the writ of subpoena. It is rule 38, order 38 rule 10 of CI 47. And on the track, how you first of all fail from 15, then from 14 is issued. The court did not even make reference to those provisions in making that ruling. And so, when you look at clear provisions of law, including statutes
The court has said in several decisions that they are the servants of Parliament. Parliament is so you look at a Parliament Court Act, Evidence Act and all that, and the court is not applying these laws. In our opinion, in this case, for us, the petitioner is not getting a fair hearing.
Okay, Sammy, just Lawyer Mesa would want to react to a few issues. We're raising now. Share a wrap up. Lawyer Mesa. No, just hold on.
I'll be on the line and listen to him.
Yes.
Masa. And like we told them, you see, the fact to say, will be a court near dismissing the case. And there's any background in the case. A very reaction, then the background now dismissing the case unanimously. A total people or not the case, and they are celebrated. And that is why today, in my address to the media, I cited the infamous, or if you like, the famous Riakutu case, which is the most, the most unpopular decision ever made by a Supreme Court, the most criticized decision.
Mm-hmm.
That decision was also unanimous. So people could have teased J.B. Dankwa at the time, who was lawyer for the accused. But the decision, that unanimous decision, and then we now call law school now your constitutional law first year, and you can't tell. A course and I near the book court, near the book court anymore. Now say lawyer Joseph Dankwa, J.B. Dankwa, or Mampenya Kukwado. The arguments are here in court, and only the chair what yes and no papa. Unanimous decision in our court on the kind of the two bed. So we have no doubts. Said and so even if not today, and for something. Now, people will see, say we were right.
Okay, my NTA lawyer Mesa, lawyer, 80 your colleagues, Sammy.
I are a whole. Oh yeah, Metsna hina Muraho. Papa. Na what's it someday one petition
and the argument you've advanced.
Assume the status of Inriakuto.
Mm-hmm.
Hey. Padisi what take one who pow. No, which part of it? The interlocutory applications that are the final decision now court in be making now. Or assume the nature of Inriakuto.
Some of the applications.
Which ones? Which of them?
So many
The review application here and the
one example.
Another Chairman,
you say
I think that the definition of the court on who an adverse witness is, for me, in my humble opinion and respectful opinion, is worse than the Riakuto decision.
Oh.
That definition, that it is only when a person has entered the box. Now I'm evidence in chief. And you're able to describe on the or your hostile witness or adverse witness. In my opinion, that decision is worse than Riakuto.
I am a Niji Papa also. The CCR workers are also in my humble opinion.
I have always said
Chairman, Ekosiisen, my co
man Kasa, why be pacho?
Inti, I am both sad and excited. Sad because you see, Obi, this decision was delivered by a 7-member bench. Their initial application, 7 justices of the Supreme Court. Now they've gone for a review before 9 justices of the Supreme Court. The justices were the Asamino. What's not doing now in our man? Sami Jefi no any lawyers no win law. Obi. Here, a care there, timer, court normal order. The parties no file one witness statement simultaneously. Okay. Did they comply?
No.
Why?
What's him? Why they didn't?
Oh, it was their strategy to find out who will file the witness statement for on behalf of the Electoral Commission. If any other person than Madame Jimesa had filed, it was Supinen at that point. But they realized that, Sanala filed that, hallelujah. How can you go to court and hinge your case on one person's witness or potential witness? A witness that the law gives her liberty to elect not to give evidence. How? Obi.
One law.
Sami Jefi.
Uncle to portion.
Order 38 or 36 of CI 47 is clear. Order of trial
on Asempa FM.
as amended by CI 87 is clear. On a party's ability to elect not to give evidence at trial. This is trite. Now, you see, they, Obi,
Asempa FM.
if you claim that you're a believer in the rule of law, if you claim the processes of court, you believe in it. If you claim that a belief in the rules of procedure and trial, why did they want us to throw it all away and go into an inquisition? Because it suits them. Why?
If it will serve the purpose of justice, why not?
What do you mean by it will serve the now? What you call it? Adversarial process they use on it doesn't serve the ends of justice. Or don't serve the ends of justice. The rules are clear. One no burden of proof. I would necessarily be a re-election. Put evidence out there. Did they? Did they demonstrate by way of discharging the burden of proof on them to suggest that somebody has stolen the election? Obi, did they? As a mommy, one of different figures. Pink sheet here will be. You have a copy of the pink sheets from the constituencies. In fact, police stations, all 38,000 plus of them. Would that be did they tell the court? Or is that not how evidence is led?
But that was not the nature of their petition.
What do you mean by that? Was not, but they said that they don't even know the figure based on which the woman made the declaration. Read their petition. And that in another breath they said that, well, assuming that we take the 34,34574 figure that she put out on the 9th, nobody won the election.
Ekosiisen on
Is that not what you're saying? So what figure did you, per your own tabulation, obtain an edible challenge what the Electoral Commissioner did? He didn't put anything before the court. Now, this argument about Section 72. Obi, read the rule near you. If you have the evidence, read it. I just can't understand that Yakusku Yakusu Nimdi.
Asempa FM.
Now, you're bastardizing on the altar of convenience.
But the fact that the definition in there runs at variance with what the Black's Law provides.
How
Black's
does it,
Law Dictionary provides.
How does it run contrary? Unfortunately, Obi, our evidence activia pulibra, because I was just looking at mine in the office. And I wonder what it is that they are really saying. It's baffling. Then they jump from one breath. Section 26, conclusive presumption. And that the Supreme Court has relegated or rather put a subsidiary legislation above substantive law. Really? Obi, statute and procedure, they are complementary.
What?
I said they are complementary.
What are you talking about?
Oh,
I said complementary.
Every statute and evidence act, the procedure, the CI 47.
Look, Chief.
Complementary to a substantive law. But the two laws I have 17, 47, and the evidence.
Why, Obi?
Okay.
Evidence. Where is it used? Is it not in the course of a trial?
In the court.
No, it is not in the course of a trial.
Yes.
And
No, Sammy. What my name you are? Yente argument no. Tobo.
An unrelated.
Sammy Jemfi, let him finish and then we can listen to your argument.
Yes. Okay. Why not just yes?
Tobo. Onye ya mo bibia. Lamesa, let me tell you.
Lawyer Mesa and the law.
CI 47 is rules of procedure that is applicable in civil litigation in Ghana.
Yes.
Civil litigation on all scope of issues bordering from contract to negligence to all those kinds of things. Now, we're working home as well. Eco Quota, Evidence Act is applicable in a trial. And the trial is conducted in accordance with the rules of procedure. So, Akohisam Ben Medi.
No. I don't want to heckle you, Julia.
But that's to my heckle. Because it is indeed a fact that the rules of procedure and statute are complementary.
You made a statement, sir.
So,
why?
In the course of a trial, the rules say that at the closure of the plaintiff's case, regardless of whatever it is that has gone in, the defendant is at liberty to elect not to lead evidence. You say, hey,
that is not what
that person is stopped by reason of statements that he's made in the trial pursuant to Section 26. That's be that. So we should try away the procedure because that's subsidiary legislation. Because the Evidence Act, you can laugh, oh. The court.
But that is not what we said.
But what did you say?
Representing everything. That is why.
What did you say? You are saying
I don't know
that
lawyer Mesa watched today proceeding.
What did you say different today from what he said the last time? Obi. Oh.
The argument is not what he's misrepresenting.
No, but Sammy, the argument has been said. Mamino making the positions being
Thank
in
you
the
very
affidavit,
much.
on which the positions are swear oath.
No, it's not. Order 38 3 5 has got nothing to do with the position or a party electing not to give evidence. What that order says is that if a party, the witness, a file witness statement,
can elect.
The party decided not to call that witness. Another party can put that witness statement in as hearsay evidence.
But that's an amendment to the existing CI 47 to
And it
deal
means that
with
the
the
party
introduction
can
of
choose
witness
not to
statement
Okay,
in our
it is
trial.
Yentio Bianca. Yenya one after the other.
A party
Look,
can choose not to call a witness. And we are telling you, sir, Section 72 say, Section 72, Section 26
26.
if a person, ama party bienya GDA say, well, be dia dance here. Not our party need and want to say GDA no so to an amodia. And this a course no Nipakona or Mass out Nipakonian GDA no point. Now, also stand aging. That person in this case is not a party. We are not talking about a party. Section 26 is not about a party calling a witness. We are not saying that the EC should be compelled to call a witness. No. We are saying that the Mensa, by her acts and statements, or you're bound by Estoppel to meet an agent. That is different from under 38 with 3E5. We say that a party can decide not to call a witness.
Okay. I think it's clear now. Lawyer Mesa.
The two are different.
Obi.
Lawyer Mesa.
Obi. That section 26, is it applicable only in a trial situation? So what's he talking about? Estoppel is applicable in a trial situation.
I didn't hear Lawyer Mesa.
You see? Sure. Issues, as far as I'm concerned, are clear. Order 38 was an amendment that was introduced to cater for the introduction of written statements in our rules of trial. In the past, when witness statements was not introduced, you give an oral testimony.
Yes.
And now, along the line, we decided that the trial process no quantum. It's introduce witness statement. And so an amendment was proffered to take care of what happens when, consistent with a party's right to elect not to lead evidence. So file a witness statement, no, decided there on my evidence or on tender in the witness statement now. What happens? What's that got to do with Section 26 of the Evidence Act? What has that got to do with it? Your right not to give evidence is enshrined in the rules. It is to suggest that my case area may close my case. During the pre-trial processes, EC will file witness statement. It may expect the EC chairperson about witness box no welcome evidence. The brain come cross-examining. And the EC chairperson, no new electoral commission, we evaluate who case at our court. Now when would the case that be maintain who case? Into they are exercising their right under the rules not to lead evidence, but ask the court to make a pronouncement based on your own evidence before the court. That's meant to be that. Now okay there about my evidence. It's one compelling number to witness box now. Maybe say some questions. What him? So the argument about she's a public officer, she's entitled to give account for her work. You see, they are jumping ship at every point.
Asempa FM.
You see, at every point when it suits them, they shift the goalpost. Clear, small. There is no consistency in the arguments. None. What for Hannah? What for her? What for how?
Obi.
Sammy.
Because my battery cold low and I'm not.
Next time, bro, studio. That's where we are invited. Nobody told you that. Do a virtual. But who told you they were there? They told me this morning that you were the one who was coming. Only some baby. One can't check now. Never come back.
Respectfully, it's not accurate.
So if I'm lying, then the producer is lying.
The producer made effort to get me to be in the studio, but unfortunately I was because my phone was
Sammy,
somewhere.
you have
allowed
2 minutes
to
to do your wrapping up.
So what you're saying is not accurate.
Sammy, 2
But
minutes,
Obi,
do your
yeah,
wrapping up.
Jamaica,
Yes.
I mean, I'll be very. You see, look, lawyer Tachichi Kata says the court has
Asempa
elevated
FM.
CI 47. That is order 38 to 35 above a statute, section 26 of the Evidence Act, because of the tense of the court's own ruling. When I make the sense, I'm talking about the wording of the rule, because the court said section 26, which talks about conclusive presumptions, is therefore inapplicable in this case, in view of order 38 rule 3E5. Meaning, say, what say? Order 38 rule 3E5 in P, and a statute which is higher than that order is inapplicable. So it means that by the terms of your own ruling, you are elevating, you are trying to say that
on Asempa
because of a
FM.
subsidiary provision, emra womremuno eyamraket 20 no emraket no won't apply. What are you doing? You are elevating the subsidiary legislation about the statutes, and we are saying that's not that. And Article 11.1 of the 1992 Constitution, which talks about the hierarchy of laws, is clear. Acts of Parliament, which is what the Evidence Act, Section 26, comes under. So it would to me change Order 38 Rule 3E5 of CI 47, which is subsidiary legislation passed by the Rules of Court Committee. Internal they are clear. Until I says I'm taking it out of context. You can't know because of the way the wording of the ruling. Or one say Section 26 of the Evidence Act is therefore inapplicable in view of Order 38 Rule 3E5. Meaning say Order 38 Rule 3E5 means I would say apply this one. And this one man. Order 38 3E5 now no yet ketwado. And yet to me, you've given it precedence over the statutes. This issue about party there will interest not to say one party there right.
Have you read the ruling?
To elect not to
And
elect.
then, and
16th ruling.
Why then?
Because the lawyer
It doesn't say what they are putting out.
Because the lawyer say even the spokesperson
Yeah,
of
Obi.
the
Obi.
respondents will be sure.
Obi.
Because no one setting the question
16th ruling, no.
Look,
16th ruling, no. Onini. Oh no, Sami can. No. It's important. Let's be clear on this. Obi Teo. We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 Rule 3E5.
what does it mean?
But the court went further to explain. Please, come on. The rules permit a party to call or not to call a witness who has filed a witness statement to testify, as the mere filing of a witness statement does not constitute an election to testify, as we rightly held in our ruling on the 11th February 2021.
Hold on. So this is my
And
position.
I'm saying to you that
that Section 26 now the court was called upon. What you hear me?
Me too.
It has got nothing to do with a party having the right to call a witness or not to call a witness.
it has everything to do with it.
It is completely irrelevant to Section 26 because Section 26 has to do with whether or not the person who is who the party, like in this case, counsel for the petitioner, is asking the court say omo odunu as bound by onwano representations in accordance with Section 26. It's not even the party. G-Mensa is not a party. G-Mensa has not said all fair witness and all fair witness. That is not the issue. So it is not even relevant. Here, Section 26 Section 26 say when the Kaya can be say in the amount of our drink. Now I go to order. Order only rule they say order 38 rule 3E5 say party bet to me decided whether to call a witness or not to call a witness. What has that got to do with whether or not that person.
But who did you take to court?
Because of one assembly Obi,
who did you take to court?
The Electoral Commission.
Thank you very much. So what are they talking about?
Rule 3E5 talks about a party. But
you took a party to court.
Hold on. Order 38 Rule 3E5.
The party's representative is who is giving the evidence.
Ruling now
Charlie, guys, look, Sammy Jeffy, look, with all due respect to you,
okay. Remember, this is what I will do now. Sammy,
you are doing propaganda all the way through, deceiving your party people all the way. But that's exactly what they are doing.
It's not a shouting match. Calm down. Don't be emotional, please.
And if the emotions are problematic,
we are talking facts.
I see.
Look, you are being emotional.
The Supreme Court
very, very uncharacteristic of you. As someone here can understand. Order 38 Rule 3E5. Number one, it talks about a party who may or may not call a witness out with witness statement about court. Number two, that order talks about the fact that the one fair witness now, the witness statements of that witness can be put in as hearsay evidence by another party. It's got nothing to do with Estoppel. The two are not even connected. And see, for us, it was not correct
the rules that set
for the
out
court
how a trial is
to have
conducted.
resorted to Order 38 Rule 3E5.
It's not
Ekosiisen.
connected.
Because of that, they won't apply Order 26. Then the main important point I can handle is in the circumstances, order Section 26 of the Evidence Act is inapplicable. Section 26, which talks about conclusive presumptions, is inapplicable in view of Order 38, Rule 3E5, which allows a party to call or not to call a witness. Really, it means that you are trying to say that BBB will Order 38 and negating Section 26 of the Evidence Act. This is common sense. That is the meaning of that English. In view of yes, no. And we are telling you, sir, even if that was a relevant statute, you cannot use it to negate an act of parliament. Because that Order 38 Rule 3, I am and then the tipping, and then the uncle, and the Evidence Act. It won't be me, and also, I won't cast a look the Evidence Act. That is the argument. This is your, the issue can testify, yes, no need to go into all these issues. The court has decided. We disagree with them, but we have accepted it because that is what our laws provide, and that is what is done for the time being. But we are very clear in our mind that the court has erred. The court has committed a fundamental error. We are very clear in our mind, sir. The petitioner has been denied a fair hearing. We are very clear in our mind, sir. The court has not applied laws of this country, statutes of this country that they are enjoined by law and their judicial oath.
Also, a fair hearing. The petitioner has been denied a fair hearing in this petition.
Yes. And I want that those additional grounds now lawyer to argue.
Hey, petition where the Supreme Court enemy.
It's unbelievable.
Article 1913 of the 1992 Constitution, which is one of the grounds for this review application we moved today, talks about an adjudication, but in this case, the Supreme Court.
Samuel Unim.
Being impartial, being independent, and giving the case a fair hearing.
No, but you thought the Supreme Court has been partial in this petition.
We are saying that we have not spoken about partiality. We are speaking about the fact that because the article talks about independence, partiality, impartiality, and giving the case a fair hearing, we are saying that they have not given the case of the petitioner a fair hearing.
Wow.
That's what we are saying.
Wow. Okay. Same mame nase na yem fancy emreninti.
Obi.
Yebehwe na ye de sia. Lawyer.
Obi.
Meba ma wrap.
Oh, I'm a wrap up na enko na ye advert na ye. One minute. One motive. Ghana full wana dwun mo da won hina we hu. Wana asame nya da. Wa court, one fair evidence bi an court court no obenya njina du bia we bu wana asam odam ho. when would they what that one supporters acher na petitioner or benewie until they have to change the narrative and paint the court black. Right from the very beginning, you went with a petition full of errors. The court granted you liberty to amend. It's not fair hearing. Right from the very beginning, the respondents urged on the court to throw your shambolic petition away. Court says no. We'll hear you. All the applications that you brought, including today,
Ekosiisen on
flatly disregarding the orders of the court to file your written addresses. One more con. 7 judges heard you. Wohunde was America merit beyond him. They dismissed your application to reopen your case. A file review. 9 judges. Apollo 9. Hey, into Mr. Sambi Jemfina NDC lawyers. I won't pay the winning answer. Wagana Kruma. I won't pay the winning bra. Supreme Court judges 9. Omen kanu koro. Yang kanu kor na Ghana. Oye na yenza. Obia mpe wunchu bia. So was some pepper bid the Supreme Court for any decisioner. This is not what we'll be hearing or seeing. Yeah, Obi.
Lord.
I've had conversations with people. NDC for social media. What Shawana Hoba? They say, but you people told us. They win election. Yanko jubilate. You organized us onto the streets, demonstrations. Yet the petition called electoral commission, we created all sorts of mayhem on the streets. Okotubo we say abrebe de yanko court na yanko prove the yedin kunim the west siena yakwa ya yesa obia we win election in the Supreme Court one order rerun. Na see him there court there kwa MPP 2013 more than 10,000 pink sheets evidence na what do kwai yan general secretary okotna box ma obi sende calculations are less na ni na waya obi win election calculation ye ni na so nanado on win ni na by more than 51%. I said don't get here when he went to the witness box. This is NDC man talking just this Sunday. So why are our party leaders deceiving us? What decoration train? What that when they know that we don't have any case before the court? It's in there. Knowing very well that one application meant who application on question baby auntie. They've changed the narrative. Now the Supreme Court is not being fair. The Supreme Court is not giving them a fair hearing. They are breaching the Constitution. They are being partial. See the narrative? Namasra NDC supporters titri one boy one annual. I don't one part in painful. They will lead them into a ditch.
Lawyer Andrew.
One boy one annual. Nanda no. Now Obi share moment around receipt. I don't know more example be wa hayo. Namasra gana fu na wo men gwen. Ya kwa kensi ene ya kwato aba mas mon use millions mon confuse obia ya 1,200 on the France work and then aprima hebie
A hebie, yes.
ya to aba ya to wie no ballot work kan in na ne won 200 o hebie wa say ye ya sinchen na waka aprimi obi enya 600 ahesia ame minya 200 ahebien akawa yan na ha otwe ntiamwa nya ahebien akawa oya apem pepepe Dominic Kisi Oboa oni ni electoral commissioner obobo aban Anna, I say total valid vote cast. Na ye to abe ye nim do ye 1,000. Or ye 1,200. Na mom obi onye 600 onye 60%. E je promise 200 20%. Ntiamwa 200 20%. Akanwa ya in 100%. Na ye hu there. Figures na ye nye ye do bomo 1,000. Manifestly 1,200 na Dominic Bueno. And you're not a valid voter or casting. That was the total votes that were cast. 200, I say. Dominic, washroom, but I catch the any that. And on the paper, Bobby. Makade, total valid vote cast or your 1,200. No, I'm not see. 1,200, the total votes you're casting in now. Valid ones, you're canning Dominic, Obi, Onya. Nimu 60%, a Japan 20, in Tiamonia 20, 1,000. Musala must not know.
Ekosiisen on
Mentasi.
FM.
Into Muko Supreme Court. There, Dominic Oboba Bado. Us there. Total valid vote cast. Yeah, a prim or Hebien instead of 1,000. Into Supreme Court, one jina, some of you Dominic Nano bed or yeah, a prim or Hebien no. No one from board there. Abani ya tu ni biya indin kunim. That's essentially what is before the Supreme Court. And this is for some other court that the court should make an order that based on a manifest error that you and I all see to declare that nobody won the election. And your supporters believe you on this. Your supporters. They believe you. So you put this whole country on a wild goose chase because of this. That declaration. Only some of you number. Obi. The fact of the figures that individual candidates will obtain in election doesn't matter. That is of no consequence. No, maybe some.
We'll come back to this.
It's of no consequence.
Mamendasi.
So how do you expect a court of law? Ekosiisen, Shrede 1,200 na what the ball abano. Maybe I win as no manche one from Aminanka Betre. That's be that.
Andrew Japamesa MP was a Kendi constituency. I don't know me here,